It's just after 4:30 p.m. Friday afternoon, and the cops have picked you up at work in front of friends and coworkers. They're taking you to the station to be questioned, an interrogation. It's a steel gray, unwelcoming place, and the lobby hums with the sound of buzzing fluorescent lights as you walk through. The chairs, made intentionally hard and uncomfortable. People walk past and stare through you, emotionless. The cops said you are not under arrest, and they just want to talk. But why did they have to dip it at your job? You're led into a small 8 by 10 box of a room with a steel table and 3 chairs. One blinking camera up in the right corner. Time seems to expand, and an uncomfortable wait begins. A wait to be questioned. As lawyers, this is when we say, now, you're on the clock. Today, we'll give it to you straight. The top 25 tactics police use to trick you and get convictions. Tactics they don't want you to know. Number 1. Lying about cameras and eyewitnesses. Officers will often ask you about an incident and seek a statement from you by claiming you were caught on surveillance or a Ring camera. Don't fall for it. Stay silent and request a lawyer. Why is this important? Alleged eyewitnesses or camera footage are powerful psychological pressure tools. They can act like an investigator's vice grip. Therefore, it's wise to remain silent and demand counsel. This approach prevents you from being crushed and jackhammered by unverified claims. Number 2. All-you-can-eat buffet. Promises of leniency for confessing or providing information. A confession is permanent. Promises often aren't. Why is this important? Officers may promise lighter treatment, immunity, even witness protection to induce cooperation. However, if you aren't careful, those promises can evaporate like steam escaping a teapot. Further, a premature confession or admission can destroy your defense in the long term. You may later learn that all-you-can-eat buffet might not be serving food, but all the jail time you can hold down. Welcome to the Four Eyes of Law. I am attorney Larry J. Brookins, a California trial attorney with over 25 years of litigation experience in both the state and U.S. federal courts. 10 of those years were spent with 2 of the largest government agencies in Los Angeles. As a lawyer, we must give our mandatory disclaimer. This video is for informational purposes only. It's not intended to provide specific legal advice about a specific case or person, or to establish an attorney-client relationship. As always, our first line of advice if you're facing a serious legal matter is to consult with an attorney of your choice. See our full disclaimer in the description. That said, let's talk law. Before we bite down, please pay this video forward and hit the subscribe button and tap the bell. This helps other people who need this information to find this video. And when you need this knowledge, you won't have to search all over the web. Number 3. Lying about evidence. You're on video, your buddy said it was you with the gun, or we found your prints. Such claims are used to terrify suspects into talking. Don't panic. Stay silent and ask for a lawyer. Why is this important? False or exaggerated evidence claims are common pressure tools. Staying calm and demanding counsel helps prevent admissions you can't take back. Number 4. Snitch switch. Turning someone in your circle into an informant happens all the time. Sometimes police will release co-defendants or offer deals to create the impression someone has flipped. The aim is to sow distrust and animosity among suspects. Be careful what you say around anyone who suddenly tries to befriend you or offer help. Why is this important? Friends, romantic interests, or new acquaintances can be recruited as informants. Limiting what you reveal avoids creating evidence against yourself. Number 5. Social media. Public stream or private trap. FaceTiming might equal facing time. Anything you post or DM may be searchable evidence, so treat your online conduct like a public stage. Digital posts and messages are easy to preserve and introduce in investigations. Avoid engaging in incriminating content or conduct on social media. Number 6. Is the TV game show The Price is Right? Just come on down. Only it's down to the station, not to a stage full of prizes. Sounds harmless until you realize a voluntary trip can land you in a deep interrogation zone and jail. Many times, a detective or cop will ask if you are willing to come to station and give a voluntary statement. Cops will that it will show you do not have anything to hide and it will help them. Big caution. Once you walk into that interrogation room, time, psychology, and duress will work against you. So, no voluntary trips to the station without an attorney. Number 7. Hands off my trunk. When a cop asks if you mind if they take a quick look in your luggage, trunk, purse, or bags, the answer should be no if you wish to protect your rights. Consent opens everything up. Consent lets officers lawfully search and seize property items. Refusing preserves your constitutional protections and helps prevent evidence collection without a warrant or an exception to warrant laws. In 1973, in Schneckloth v. Bustamante, the Supreme Court ruled that consent searches are valid. Further, law enforcement is not required to tell a person they can refuse consent. So, simply say, "I do not consent to a search," and keep that trunk closed. Number 8. The warrant whisperer. Sometimes officers will pretend a warrant is on the way, implying you might as well let them search. Don't let street theater push you into agreeing to a search or admitting things you shouldn't. Why is this important? Fake or threatened warrants are pressure tactics designed to gain consent. Number 9. Can you smell the roses? The sniff game is a common tactics cops use. Don't fall for it. Cops will claim they smell marijuana or other contraband. This false assertion is often used to create probable cause on the spot. Your confirmation of a claimed smell may be used to justify an immediate search or arrest. Don't start admitting to things and becoming the cop's assistant against yourself. Assert your right to remain silent and say you do not wish to talk without a lawyer. This helps prevent or reduce escalation. Number 10. The ticket trap. Oftentimes, an arrest for a minor offense will enable a search or justify custody. Why is this important? Minor citations can be a pretext to detain you longer, search a person, or build a case. Recognizing this tactic lets you refuse unnecessary searches and insist on your rights right away. If this video has been helpful, please hit the red subscribe button below and tap the bell so you'll automatically notified when our next video drops. Number 11. It's off the books. Sometimes an offer may say that any information you give will be off the books. That may be true, but it doesn't mean it's off his report. That very officer's notes can be used to send you to jail. Informal chats and casual talk are often recorded as evidence and testimony. Treat every talk like an interrogation. Why is this important? What seems casual can be written down and treated as evidence later. Staying guarded prevents you from inadvertently providing usable statements. Number 12. Body double body talk. Don't overreact when being questioned. Every good poker player knows the value of maintaining a poker face and steady posture. Every twitch gets read as evidence. Stay composed and don't improvise explanations. Remain silent and ask for a lawyer if pressed. Why is this important? Officers and investigators look for behavioral cues to support their narrative. Staying calm limits the chances your behavior will be spun into probable cause or evidence of a crime. Number 13. The voluntary encounter trap, also referred to as the "Are you free to go?" question. This is a key question a person should ask very early after being stopped or detained. The answer to this question lets a person know if they are under arrest or not. Ask, "Am I free to leave?" If the officer says yes, say thank you, shut up, and leave. If the answer is no, then immediately know that you are either under arrest or being detained. In either of the last two instances, the best approach may be to say, "I wish to remain silent and would like a lawyer present." The Supreme Court has ruled that it is not just the words police use to determine whether a person is under arrest. It's the officer's conduct as well. For example, if the cops say you are free to leave, then grabs your arm or blocks your way, it's an arrest or detention. Why is this important? If you're detained, you lose the right to walk away, and officers may escalate the situation if you attempt to leave. Clarifying your status protects your liberty and explains what rights you must ask for, including the right to an appointed attorney. Number 14. Front door. Knock and talk. Inviting officers inside your home may waive many protections. If possible, speak through the door or remain in the doorway. Why is this important? Letting officers into your home often waives Fourth Amendment protections. Keeping the interaction at the threshold of the front door helps preserve your right against warrantless searches. Number 15. Police lying about the law. Giving misinformation is a common trick officers use as a way to obtain information and evidence. Stay calm, assert your rights, and get legal counsel if needed. Why is this important? Officers may misstate legal rules to gain compliance or an advantage, so recognizing this helps you avoid inadvertently waiving your rights. Before we continue, if this video is helpful, please hit the red subscribe button and tap the bell. It will help others who need this information. You'll automatically get notified when our next video drops. That way, you won't have to search all over the web when you need legal insight. Number 16. You don't need no stinking lawyer. Translated, when you hear a cop say this, lawyer up immediately. Simply say, "I wish to remain silent and want a lawyer present before speaking." Many times, that will immediately halt questioning. It has been discovered in many situations that this was the single best move a suspect chose toward protecting themselves. Why is this important? Invoking counsel stops questioning and prevents self-incrimination. Number 17. The two-faced friend, also known as the good cop, bad cop dance. It's a well-known tactic still used effectively today by law enforcement. One officer pretends to have empathy for your situation, while the other shows extreme hostility towards you. It is designed to psychologically squeeze and manufacture confessions. In reality, both officers are on the same team, and it is not yours. Number 18. Your buddy has already talked. This tactic is meant to isolate and make you feel betrayed. Don't be pushed into blaming or bargaining. Why is this important? The tactic aims to make you feel alone and desperate for sympathy, which can lead you to say things you shouldn't. Recognizing the tactic will help you stay silent and wait for legal counsel. Number 19. The undercover ear, the hidden police agent. Trust no one. You could be talking to someone planted to collect your words to be used as evidence. Never volunteer details in casual conversation. That cute person you just met at the gym? Forget it. Why is this important? Undercover officers and informants harvest casual remarks and turn them into evidence. Number 20. Too good to be true. Walk away. Undercover sting operations. Strangers pushing illegal deals are often cops in disguise, engaging in what they do best, arresting people. Why is this important? Sting operations are designed to induce participation. Refusing suspicious offers may protect you from entrapment. Number 21. Confess once, go to jail twice. Once you confess, it's brutally hard to undo. Why is this important? Admissions stick, They're often introduced at trial and are extremely hard to retract. Number 22. Do you know why I stopped you? No is the answer. A closed mouth may avoid jail. Don't prosecute yourself. An inadvertent or offhand comment can wreck a legal defense. When an officer asks such a question, the cleanest, smartest answer is no officer. Number 23. Report polish, paper trail theater. Officers may clean up, embellish, or coax you to clarify a statement that later becomes formal evidence. Don't sign anything or agree to a quick summary without counsel. Why is this important? The officer's report often becomes the official version of events and can lock in facts that hurt your case. Number 24. The friend of the court trick. An officer might tell you, "Look, I'll put in a good word with the judge if you just help us out." Why is this important? Because cops don't control judges, prosecutors, or sentencing. That's pure bait to make you talk. Only prosecutors and courts can offer real deals, and even those must be written and approved. So when you hear them say a good word, translate it as a trap word. Finally, number 25. Just want to clear things up and close the file. Detectives may say, "We just want your side of the story to close the file." Sounds innocent, but in actuality, they just want to open the file. And with your help, they can do just that. Once you speak, you can't unring the bell. Why is this important? The smallest slip-up can become the foundation of probable cause and the foundation for a conviction. The safest side of the story is silence until you are represented by counsel. If this video has been helpful, please pay the video forward and hit the red subscribe button below and tap the bell so others who need this information can find it. And you'll automatically be notified when our next release drops. Now, check out this next video.